House of Representatives. The Constitution provides for the composition of the House of Representatives. Not more than 250 members unless otherwise fixed by law. Take note, unless otherwise fixed by law. Congress may by law increase the 250-member composition prescribed by the Constitution. The 1987 Constitution fixes the maximum number of members of the House of Representatives at 250. However, the 1987 Constitution expressly allows for an increase in the number of members of the House of Representatives, provided a law is enacted for the purpose. This is clear from the phrase, unless otherwise provided by law, in Section 5, Paragraph 1, Article 6 of the 1987 Constitution. The legislature has the option to choose whether the increase in the number of members of the House of Representatives is done by piecemeal legislation or by enactment of a law authorizing a general increase. Legislation that makes piecemeal increases of the number of district representatives is no less valid than legislation that makes a general increase. Now, the House of Representatives consists of the district representatives and the party list representatives. The district representatives are elected from legislative districts apportioned among the provinces, cities, and metropolitan Manila area. The party list representatives shall constitute 20% of the total number of representatives elected through a party list system of registered national, regional, and sectoral parties or organization. 1/2 of the seats allocated to the party list representatives shall be filled as provided by law, by selection or election from the labor, peasant, urban poor, indigenous cultural communities, women, youth, and such other sectors as may be provided by law, except the religious sector. These members are referred to as sectoral representatives. Now, what are the qualifications for a member of the House of Representatives? He must be a natural-born citizen of the Philippines, at least 25 years of age on the day of the election, able to read and write. Except the party list representatives, must be a registered voter in the district in which he shall be elected, and must be a resident thereof for a period of not less than 1 year, immediately preceding the day of the election. The term of office of a member of the House of Representatives is 3 years. Now, take note that aside from the qualification as natural-born citizen status, all qualifications of the members of Congress must be present on the day of election or the day immediately preceding the day of the election. However, the status of a natural-born citizen as a qualification need not be present on the day of the election as long as the same is obtained when the elected officer's term of office begins. This happens when a former natural-born citizen loses his citizenship but subsequently applied and qualified for repatriation. As to re-election, a member of the House of Representatives shall not serve for more than 3 consecutive terms. Again, a member of the House of Representatives shall not serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. Now let's talk about the rules on the apportionment of legislative districts. It shall be made in accordance with the number of respective inhabitants on the basis of a uniform and progressive ratio. Each city with not less than 250,000 inhabitants is entitled to at least 1 representative. Each province, irrespective of the number of inhabitants, is entitled to at least 1 representative. Take note that the 250,000 minimum population is only required for a city, but not for a province. Each legislative district must be contiguous, compact, and adjacent. Relevant rulings on reapportionment of districts. Reapportionment of legislative districts may be made through a special law. While Section 5, Paragraph 3, Article 6 of the Constitution requires a city to have a minimum population of 250,000 to be entitled to a representative, it does not have to increase its population by another 250,000 to be entitled to an additional district. The minimum population requirement is only applied in the initial apportionment of a city, but not in the subsequent reapportionment of additional legislative districts in the city. This was held in the case of Mariano versus Comelec. In another case, the court held that the Comelec is denied the power of reapportionment by the Constitutional Commission, as can be gleaned in the ordinance appended to the Constitution. At most, it can only do minor adjustments. That is, when the Constitutional Commission forgot a municipality or error in the correct name of a particular municipality. But it does not have the authority to transfer one municipality in a district to another district, as the same does not constitute a minor adjustment. The power to create a province or a city with a population of 250,000 or more requires also the power to create a legislative district. Even the creation of a city with a population of less than 250,000 involves the power to create a legislative district, because once the city's population reaches 250,000, the city automatically becomes entitled to one representative under Section 5, Paragraph 3, Article 6 of the Constitution, and Section 3 of the ordinance appended to the Constitution. Thus, the power to create a province or city inherently involves the power to create a legislative district. The power to create a city or province has never been delegated to the Regional Assembly of the ARMM. Such power is exclusively vested in the Congress. Regional Assembly may only create barangays or municipalities.